Okay, the next case on our docket is dependency of NBG. So we'll give council a minute to swap out. Morning, council.
Morning, Your Honors. Christopher Petroni with the Washington Appellate Project for the father in this case. And I'd like to reserve 3 minutes for rebuttal, please.
Sorry, 3?
3, yes, please. Guardianship is a permanent option for a dependent child. And when a guardianship is available, severing the parent's rights is not necessary for that child to achieve permanency. The trial court here erred in terminating my client's parental rights because 2 of the findings on which the judge reached that conclusion lack support in the record. 1, that there was no willing guardian, and 2, that the department made adequate efforts to support guardianship with that particular caregiver.
Can I pause even right there? So we're boiling this case down to just 1334 180F, which is the availability of a suitable guardian. Which is that this relationship between BG and his kids would clearly diminish the kids' prospects for early integration in a stable and permanent home. That's boiled down to the 2022 amendment. And the question there is whether the court considered the availability of suitable guardianships and the department's efforts to find that guardian. There's no dispute that the court considered it, right? In other words, it feels like you're asking us to consider the merits or the substance of the court's reasoning behind the considerations, right? But isn't the statute at most just requiring the court to consider it, and there's evidence in the record that it did? Shouldn't that end our inquiry right there?
It should not end our inquiry, Your Honor, because it isn't enough merely that the court considered whether a guardianship was available, where that consideration was based on a finding that's contrary to the law and the evidence in the record. A guardianship is available within the meaning of the amendment, where if we refer to what a guardianship is in Chapter 1336, a guardianship is available if 2 prongs are satisfied. 1, if there is a person who qualifies to serve as a guardian and who is willing and able to fulfill the duties of a guardian. And 2, where a guardianship rather than termination would be in the children's best interests. Now, the juvenile court here.
Who gets to decide willing and able?
The trial court. The trial court decides willing and able.
But what is that based on? Is it the person saying, yes, I'm willing and able, or some, more objective standard of, yes, this person, again, you've got the qualified, that's a different factor. But isn't a statement that I don't want to be a guardian, I would rather adopt them, doesn't that make the person not willing and able?
The finding of whether a person is willing and able should be based on all the evidence in the record. And of course, the caretaker's own testimony about what they are willing to do is very important to that determination. And a caretaker—
Why isn't it dispositive? What if they say, I don't care, I'm the most obstreperous person you've ever met, but I was present at these children's birth and I care deeply about them. And I am willing to be their adoptive parent, but I have no interest whatsoever in a guardianship. And I won't do it unless for some reason I'm coerced by the government to do it. Are we in the business of coercing nice people who seek to come to the aid of children who don't have either parent who's capable of taking care of them? Is that what this is about?
It certainly is not about coercing parents to do anything, Your Honor. If a parent, excuse me, not a parent, if a caretaker who is a candidate for guardianship testified that they were absolutely not interested in guardianship, I would think in most cases that would be dispositive of whether that person is willing to be a guardian. But where a person testified, as the caretaker did here, that they are willing to be a guardian, to serve as a guardian, if that is the only option available to have custody of the children, then as a simple matter of logic and the law, then a guardianship is the only option for them to.
But the question is there substantial evidence for the court's conclusion, right? In other words, we can have a normal conversation. There are misunderstandings going left and right, like most conversations. But what I'm hearing, what I'm interpreting is this person does not want to be a guardian. The question is there substantial evidence for that? The court's interpretation of what the witness is saying, the caretaker is saying. Isn't that the analysis we're doing? not whether there's some sort of black and white box we can put it in, willing, not willing, but what the court heard and used to support its conclusion that this person was not willing and thus not available.
Well, certainly, Your Honor. The question is whether substantial evidence supported the trial court's findings. And here the finding was contrary to the evidence because the caretaker.
Would you make the same argument if the finding was this person would only submit to being a guardian if compelled under duress? The duress being a fear that these children would be so much worse off being tossed back into the foster care system than the government allowing this person at issue to continue to be of assistance to them. I mean, what's going on here is duress. You're arguing in favor of duress. Someone who is forced under a feeling of duress to comply is willing. And that's not true in any other area of the law. And it would surprise me that it would be true in this particular area of the law.
Well, I disagree with that interpretation of the record in this case for two reasons. One, simply straightforwardly applying the law, which as a matter of logical impossibility, when a guardianship is available, termination is not available because guardianship is a permanency option that does not require severing the parent's rights. So it's by simply following the law to its logical conclusion is not coercion. If it is, all of us are being coerced every moment of our lives because we all live our lives subject to the law. And second,
Well, you've answered the question by assuming the answer to the question, by saying that because a guardianship is available.
Well, there's another piece of that question of whether a guardianship is available, and that's whether a guardianship is within the children's best interests. Merely because a person who could be a guardian exists doesn't necessarily mean a guardianship is legally available. And here, the juvenile court perhaps could have found a guardianship with this particular caretaker was not in the children's best interests, but the trial court didn't address that question. It resolved the question of availability solely on there being no willing guardian. So that doesn't assume an answer to the question. If this person was willing to be a guardian, and if guardianship, as opposed to termination with this particular person, was in the children's best interest, then a guardianship was available and termination was legally unavailable.
What's your best cite, real quick, to the record? What's that she said what you just said she said? What is your best cite? Do you have one? Maybe when you come back up, you can just give me the exact language she said that the court, no reasonable person would interpret this in any other way but the way you want us to interpret it.
Well, the best cite I have is what is in the briefs, which is pages, and I'll correct myself on rebuttal if this is incorrect, but I believe it's pages 281, that's caretaker's testimony, and page 147, which is the assigned social worker's testimony. Thank you, Your Honors.
Thank you.
Good morning. You may it please the court. Juliana Rice, Assistant Attorney General for the Respondent, Department of Children, Youth and Families. 7 months ago in the GCB case, this court rejected the argument that the 2022 amendments to Chapter 1334 embedded a preference for guardianship in that statute. The legislature chose to leave discretion with the trial court to resolve dependency matters by case-specific analysis of what the children's best interests require. Exercising that discretion, this trial court determined that adoption over guardianship was in the children's best interest. This decision deserves affirmance for two primary reasons. One, guardianship was not available. It was not available in the literal sense because there was no willing guardian. And to Judge Dwyer's point about whether the record shows that the caregiver would have accepted guardianship only under duress, I very much agree that the record does show that. And a review of the caregiver's testimony quite clearly establishes that the only way she would accept guardianship is if it was necessary to keep the children in her care. Guardianship was also not available in a legal sense because it would not serve the children's best interests. Therefore, the requirement of Chapter 1336 is not met. What is required to establish whether the department has made reasonable efforts to explore guardianship? And here you've got numerous conversations. I'm curious, particularly, to take the witness's testimony at face value about what she thought that meant, but what do you think is required of the department? Do they need to explain how a guardianship would work, for example, or what benefits might be available to her she chose to take that route?
Yes, I do believe that, Your Honor. I believe that the department, from the very beginning of the case, needs to be looking for placements, the law requires it, with relatives or suitable other persons, such as the caregiver here. Those are persons who would be more likely to have connections to the child's family of origin, and therefore might be more likely to be an appropriate guardian. The department needs to educate caregivers after a caregiver has had care of a child for 6 months or more, on the features of guardianship, particularly a more modern guardianship. I'm calling it under Chapter 1336. The law allows a one-time payment for someone in the position of the caregiver to seek counsel to answer further questions. The record is silent on whether that happened here. But certainly the department needs to give accurate information. What the department does not need to do and should not be doing is pressure any caregiver or push for an outcome that is not in the child's best interest. If the department concludes from the beginning that the child should not have any further contact with a parent, and therefore guardianship, the main feature of which is to preserve that parent-child relationship, is not appropriate, an appropriate permanency outcome here for that child, then the department may not take efforts to explore a guardianship, which the department has the discretion to do under the law, and then merely needs to explain to the trial judge why it's taken that view. I'm sorry, Judge
If I
Schwager.
adopt a 10-year-old child, how long does that relationship last?
Legally, forever.
Okay. If I become the guardian of a 10-year-old child, how long does that relationship last?
Until the child is 18, Your Honor.
So what's really happened here is that only lawyers would think that something that lasts for 8 years is permanent, as opposed to something that lasts for a lifetime. So this woman's sin is applying the word permanent as she conceived of it, as any normal person in society would conceive of permanent, and not thinking like a lawyer and rushing to the Revised Code of Washington to study the notion of permanency in Title 13 or elsewhere, right? I mean, that's what it comes down to. She had a normal layperson's understanding of what permanent meant, and this to her was guardianship to her was not permanent. If she died and had adopted the child, and the child was 22, but she had no will, the child would take as an intestate child, but not so if it was just a guardianship, because to normal people, they're not the same.
That's correct, Your Honor. And I'm not sure if the guardian or if the caregiver actually used the word permanency or permanent, but it certainly is used and used a lot to mean different things in this case. Even the old, what we call the old dependency guardianship under Chapter 1334 was viewed by the appellate courts as, quote, permanent, even though the dependency case remained in place and the court remained involved. The AW case from the Supreme Court in 2015
So
tells us
is
that.
it a transgression for the department not to disabuse her of her normal person's view of the word permanent and educate her as if she were a lawyer to have an understanding of permanent in the sense of permanency, which means until somebody's 18?
The record reflects, Your Honor, that the department did advise this caregiver that guardianship is not considered a temporary option. Permanency under the law means until a child turns 18. And that word is used both to refer to adoption, to a Chapter 1336 guardianship, and even the old dependency guardianship.
But it's not actually permanent. It's just defined in that way in a bill the legislature passed, but it's not true.
Any
It's
child
not true.
care.
This child at 30 would still be the adopted child of an adoptive parent.
Yes, Your Honor. Any child care arrangements can be permanent, or any permanent arrangement can be undone. This
Well,
caregiver
it doesn't have to be
could.
undone. It has an endpoint.
Cor-
You've already answered that.
Yes,
Right?
correct, Your Honor.
It has an endpoint. The reason it has an endpoint is because it's not really permanent. It's only permanent as lawyers think about it.
I don't disagree with Your Honor's view that permanency can mean different things to different people. And what this caregiver understood intuitively was that a guardianship under Chapter 1336 carried additional risk of disruption that is not present in an adoption. To be sure, it is less risk of disruption than under the old Chapter 1334 guardianship, but it is not no risk. And therefore, the caregiver's viewpoint, as explained to the court.
So if the client of counsel came in later on, initiated a court action to terminate the guardianship, who pays for her lawyer?
She would pay for her own lawyer.
Well, that doesn't sound like a very good deal. Was that explained to her by the department?
The record doesn't reflect that, but if that question was raised, certainly that would have been explained to her. It's not clear that paying for a lawyer was her main concern. What her concern was.
She was concerned about court action though, right?
She was concerned about disruption to the girls' lives. The record reflects that the girls did not do well with ongoing interventions associated with the dependency case. She wanted that to end. She wanted to be able to make them promises that she knew she could keep. That doesn't mean she wanted to cut off.
But part of the presentation in the briefs is that her fear of court action to her was overstated, or what she believed it was overemphasized, because if it was without merit, the court would, of course, just disposed of it easily, the complaints. But that would still mean she either was pro se or she was having to hire somebody with her own money.
Correct, Your Honor. And even if it would be unusual for the department to intervene on her behalf, this is a case where the dependency would have been dismissed upon entry of the guardianship order. The department would have no current knowledge of the child. But even if the department were able to come in and represent her, that doesn't mean that the court action would be non-disruptive to her. It would be disruptive in a different way. People would be coming in to interview the children. They would be confused, as the record has shown they have been through the dependency, and afraid that their placement would be disrupted. So unless the court has further questions, the department requests affirmance of the termination orders with respect to both children in this case. Thank you.
Thank you.
The department errs in saying that a guardianship was not available because it would have been in the children's best interests. The juvenile court made no such finding. It would be inappropriate for this court to make that finding for the first time on appeal. As for the department's efforts to support a guardianship, the department's argument just now demonstrates that there is no evidence of what the guardian was, the potential guardian, the caretaker, was told about a guardianship. When asked whether the caretaker was told particular things about a guardianship, the answers were, the record is silent, or the record doesn't reflect that. Even if.
Well, the record also doesn't reflect whether how your client would have reacted to a guardianship being imposed in this situation. And we're pretty confident of that because your client didn't bother to show up at the trial. So where does that leave us? Where she says there's testimony that she's concerned about things, and he isn't there to testify that those are meritless concerns because he just doesn't show up.
I think even without my client's testimony, there is that those concerns about the guardianship being disrupted through litigation are meritless because of the limits that the guardianship
So the
statute
way to
places.
do this is not to show up. He made a correct strategic decision to not show up to his termination trial because that then deprived us of having a record to review this.
There is absolutely no evidence to find that my client's inability to attend, my client's inattendance at trial was a strategic choice. And it's inappropriate to make factual conclusions against him for that reason.
Why is it inappropriate to assume that he didn't have a reason for not showing up? I mean, he's given permission to you to prosecute this appeal, right?
Certainly.
Okay, so obviously then that's an indication they had an interest in how the case would come out. So why is there no information about why he didn't bother to show up for the trial?
Because parents in dependency cases, all sorts of dependency cases, face all sorts of barriers and difficulties in.
No, that's a
participating.
generalized statement. I'm saying, what's the indication why he didn't show up?
I don't think.
I know, we have this appeal, so I know that's so, but why didn't he show up?
There's no need for me or for any representative of my client to present evidence to justify why he didn't turn up.
Only if you're seeking to exploit the absence to a tactical advantage.
I take strong offense to that characterization, Your Honor. And the department hasn't tried to do that.
I don't mean it to be offensive towards you.
I just think it's inappropriate in this case to draw adverse inferences against my client because he didn't turn up at a trial that he was not required by law to turn up to. And I would ask this court to reverse and remand for dismissal of the termination petition. Thank you, Your Honors.
Thank you.